Arbitration and insolvency, both very important institutions, are conceptually different. Arbitration arises out of party autonomy, the cornerstone of which is consent. Arbitration is a delocalized mechanism recognized globally, especially given the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, popularly known as the New York Convention. Insolvency, on the other hand, is a governmental mechanism for domestic economic objectives. The general rule is that as soon as insolvency in respect of any entity is triggered, all litigations and pending dispute resolutions are suspended or abated. This notion also extends to arbitral proceedings. What happens when a party to an arbitration agreement goes insolvent? That can happen either during or before the subsistence of arbitration proceedings. These triggers can also kick in at the stage of enforcement of an arbitral award. Going by the general notion, most arbitral tribunals, just like domestic courts, would suspend or discontinue proceedings against an insolvent entity. It could also happen that the claimant, during or before the arbitration proceedings, goes insolvent, impecunious, and does not have the ability to contest its claims. Some of the developed jurisdictions around the world have been more liberal and have allowed arbitration proceedings to continue in respect of an insolvent respondent. When it comes to enforcement of an arbitration award against an insolvent debtor, the system is very unsparing. When it comes to enforcement of an arbitral award, what has to be looked at is the capacity of the party or the public policy of the nation where the enforcement is being sought. A court, when confronted with the enforcement of an arbitral award, will look at the public policy as if whether it's domestic, governmental, transnational, or international. Given the pandemic around the world, a lot of businesses have either undergone insolvency already or otherwise are on the brink of it. These businesses could either be claimants or respondents. In the times to come, third-party funders are likely to assume a new and pivotal position as regards international dispute resolution. Third-party funders are largely unregulated, and especially given the confidentiality requirements, do not disclose the exact terms of arrangement with the claimants. Of late, there have been some decisions which have criticized the involvement and role of third-party funders or the impact they can have to the continuation of proceedings. While on the one hand, there is a right of an impecunious claimant for access to justice, on the other, third-party funders often end up governing to which extent they will extend support. Whether or not that would cover security for costs is another matter. A big question is whether arbitration proceedings should be allowed to continue when insolvency has been triggered in respect of one or both of the parties. What should be looked at by the arbitral tribunal? Is it competence? Is it the first principles? Is it public policy to be determined or applied by the arbitral tribunal, or how it would be applied by the courts at the stage of enforcement? There are a lot of questions. The jurisprudence around this interplay is largely underdeveloped.